In the next couple modules, my good friend Rich Goldstein, who's one of the top IP attorneys in the entire world and really well known in the e-com space, is going to show you and talk to you about some of the things you need to be thinking about when it comes to patents, trademarks, and copyrights. He really knows his stuff. He's written a book on the subject for the Bar Association. So pay close attention to what he has to say and enjoy.
Rich Goldstein here, and I'm a patent attorney, and so I want to start talking about intellectual property. In particular, I want to talk about intellectual property and how it affects your journey as an Amazon seller, because it could have a big impact. And I would boldly say that intellectual property might be the thing that you know the least about that could have the biggest impact on your journey as an Amazon seller in various ways. One of the reasons why intellectual property is important is because you want to establish brand registry, which we'll talk about later. Also, you might begin to notice during your selling journey that it's important to differentiate your product. If you're selling the same product as many other people, then it could be a lot of effort for very little in return. And as sellers continue in their selling journey, they begin to realize that differentiating their product can make a big difference, especially if they could differentiate the product in a way where other people can't then do a Me Too product. Other people then can't copy the differentiation that you establish. And that's where IP comes into play. If you could protect the thing that customers begin to look for in your product, then that gives you the ability to maintain that differentiation and maintain your status among other listings. And then also having IP can be extremely valuable at the point of exit. So where many Amazon brands are being acquired by others these days, when they're applying significant value, not just to the amount of market share that you're able to establish, the amount of earnings that you could establish, but also to the IP portfolio. Because to a large extent, if you could establish a brand, that's protectable. If you have product concepts that are protectable, then that gives additional leverage to someone who's purchasing your company to then expand into other channels. Because a lot of times brands that are being acquired are then being moved off Amazon into other channels, such as Shopify channels, and also even into retail stores. And having protection over the IP then gives them that much more perceived value, someone who's buying your company, that is, that much more perceived value in what they could do with your product once they do acquire it. So those are reasons why you ought to pay attention to IP. And an additional reason, of course, is avoiding IP complaints, is having IP, having the right IP, and doing the right diligence with regard to IP can help you to avoid a situation where your listing gets shut down because of an IP violation. So overall, it's extremely important for you to learn more about IP. And I'd like to do my part by giving you a little bit of knowledge here that could perhaps help you to get yourself protected and to avoid some of those more difficult situations, especially the situations which, with a little bit of knowledge, you could easily avoid. So let's get into it. And so we're going to start here by talking about patents. And before we talk specifically about patents, let's just clarify a few things, because people get confused often between the different types of IP. And by the way, I keep saying IP, and IP is short for intellectual property. Intellectual property is the area of law that deals with the protection of ideas. And the main branches of IP that you often hear of are patents, trademarks, and copyrights. But again, people often get confused between these areas, and they'll say things like, well, that's a great idea for a book, you should copyright it. I'm sorry. That's a great idea for a book, you should patent it. Copyright actually would be correct in that instance. Or that's a really cool product idea, you should get a trademark on that. And again, that's incorrect. That would represent a mismatch between the type of thing that you're seeking to protect and the type of protection, because you can't patent a book and you can't trademark a product idea. And so let me just go over the distinction between the three. So when it comes to copyright, what we protect with that is content. So it could be content by way of the words on a page in a book. It could be the words in a listing, like an Amazon listing, could be protected by copyright potentially. It could be the content of a movie or a musical composition. In other words, a song or a sound recording in a song. That type of content all gets protected by copyright. When it comes to branding like the name of your product, the logo for your product, things like that, the things that consumers use to determine what company a product is coming from. You see Coca-Cola, you know it's coming from the Coca-Cola company, and you see their red and white color scheme on their can with that special writing of the logo of Coca-Cola that we're accustomed to seeing. Those are all branding aspects that people associate with Coca-Cola. So that's what a trademark is for. So trademarks protect branding. And then product ideas, the thing that differentiates a product, the structure that makes a product function differently, even the shape or design configuration of a product, that's protected by patent. So patents protect products, trademarks protect branding, and copyrights protect content. Okay, and so let's talk a bit more then about patents. I think in the next module after this, we'll talk more about trademarks. But for now, let's talk about patents. And again, patents protect the product differentiation. Patents protect the thing that makes your product different from other products out there. And there are two main types of patents that you want to be concerned with or want to know about, and that's design patents and utility patents. Now, a utility patent is what we typically think of when we think of a patent. Like when we think of someone in their garage coming up with a new idea or having a problem that they're seeking to solve, and so they come up with a new type of soap dispenser that avoids this certain type of thing from happening, it has structure that keeps you from wasting soap. Whatever that structural difference is, that functional difference is, that's what you would typically protect with a utility patent. So it's what we typically think of when we think of someone patenting an invention, is we're thinking of a utility patent. But now there's also design patents, and what a design patent is for, it's just for the shape of a product. It's for the ornamental appearance of the product, more particularly. And the shape could be one example of that. But it's really about that look, that design configuration. And what gets protected there is just the way the product looks. So if a product looks differently than in the patent, then it might not infringe that design patent. So traditionally, people have looked to design patents as being less important or less valuable than utility patents. But that's not necessarily the case on Amazon. And let me explain why. So often, like if you've got a product, and let's say you have a utility patent and a design patent on it, and you see that someone else is really copying your product, and you want to make an IP complaint to Amazon. Well, the first thing that you do is you would submit the patent to Amazon. But let's look at the difference between the two and how they are interpreted. So a utility patent is all about words. It's about a specific definition. It's about a definition in words defining what the invention is, that it has A, B, and C, that it's a table that has a platform with 4 legs and it has a drawer attached to the bottom of the platform. Like that definition defines what someone would need to do to infringe the patent. A design patent is about the way it looks, the way that it looks in pictures. If you are going to infringe that patent, the way you do it is by having something that looks substantially similar to the way the patent is in the drawings of the design patent. So now imagine that, again, you have both of these patents, you submit them to Amazon, you're doing an IP complaint. Amazon, with the utility patent, is now forced to interpret the wording of the patent. They're forced to interpret, does this other competitive listing have Is it a table with a platform with four legs extending downwardly and with a drawer attached to the underside of the platform? Does it meet that definition? And, Amazon doesn't want to get into interpreting legal documents. But on the other hand, with your design patent, when you submit an IP complaint, now they're tasked with comparing pictures. They're looking at your design patent drawings and they're looking at the competitive product and they'll say, does it look the same? It does. And they'll shut down the listing. Sometimes unfairly. Like sometimes like there are reasons why it shouldn't be compared the way that it is. But Amazon, if it looks similar to your design patent drawings, will shut down that listing. So it pays to be the one holding the design patent. So that's one of the reasons why design patents can be quite valuable on Amazon, where in the outside world, people say, well, they're not so valuable. You change the way it looks and then you get around the patent. Yes, but it's a much easier path to get a listing shut down with a design patent than with a utility. So design patents have become extremely valuable on Amazon. And often I'll tell people that if you have a product that is distinctive in appearance, that you ought to do a design patent because, especially if it becomes a six-figure product, then it becomes a no-brainer to have it protected because you spend a few $1,000s on a design patent, and then suddenly one of your competitors makes an exact knockoff, which is how people tend to knock things off on Amazon. They tend not to get imaginative about it. They don't say, well, that's a cool product there. Let me take that as inspiration and come up with my own product design. They just copy it exactly. And so if they do that and you have the design patent, it's going to look the same and then you'll be able to shut them down. And then if you have a six-figure product and you're able to shut down a competitor who's taking just a little piece of your market share, it could be a huge ROI to have gotten that design patent. Okay, so then that's essentially the difference then between the design patent and utility patent. And again, being that Amazon tends to be deferring to IP owners, it pays to be an IP owner. It pays to be the one holding that patent. Now let's look at the standards for what it takes to get a patent. In order for something to be patentable, it's pretty elementary that it needs to be different, right? I mean, like we don't think of patenting an old invention. We patent something that's new, something that's different from things that existed before. And that's why, it has to be new. Part of the standard is that it needs to be novel, meaning different in some way from things that existed before. That's the easy part. But then there's also non-obviousness. And this is especially important for utility patents, is that it has to be outside the range of what people would typically think to do. Like maybe, you've got a pen and you're like, well, my pen is 11 inches. Mine is a 11-inch ballpoint pen. Can't find any specific examples of an 11-inch ballpoint pen, but that's something that the patent office would say is obvious because, they would recognize that people that make ballpoint pens know they can make them of any length. They just make them a specific size because it tends to fit in most people's hands. So just changing the size of something wouldn't typically lead you to a utility patent because it would be considered obvious. So for something to be patentable, it has to be new and non-obvious. And now moving beyond that, let's talk a little bit about timing of it. So a lot of times people will launch a product and recognizing that patents can be expensive, they'll say, well, let me launch the product. And if things go well, then I'll apply for a patent. The problem is that once you put the product out there, once you make it public, then you immediately lose the rights to patent it in most of the world. And in the US, if 1 year goes by from that public disclosure, then you have lost the rights forever to get a patent on this, to get a patent on that product. And it happens way too often that people don't even know about that 1 year grace period in the US. And they come to me 2 years after they've been selling a product and it's just too late. So what you want to do is you want to explore whether it's something that you should be patenting before you launch the product. That's the right time to do it. And I'm not saying that you should patent everything because it could be prohibitively expensive to patent everything. And especially if you're just starting out, you might not want to patent the first product that you're launching. And uh, but you want to carefully consider whether this one should be patented. And if you're going to do it, the time to do it is before you launch, or you move forward and you don't look back. Or you move forward, you do your best to get your product out there, and you put your efforts into launching, into promoting, into expanding your brand, and you don't look back towards protecting it, and just let the chips fall where they may. And that's typically the approach you want to take. But again, you want to make that determination early. And part of what the determination should be, and this is what you don't hear very often, and this is what most patent attorneys won't tell you, and that is that you want to determine whether you're likely to get a patent that's going to be valuable to you, that's going to be of the right scope. Now, what does that mean? Every patent has a scope, meaning what does it protect? What's the zone of what it protects? Because some patents can be very broad and cover a new concept, while others are rather specific and are in particular limited to maybe the fine details of the product. And usually this comes about when a patent isn't all that new to begin with. So often what happens is the concept isn't that different from things that already existed. And so what you end up getting is a patent that's more on the details. You see, if the concept was new, you can get a patent on the overall, but if it turns out the patent isn't as new as you expected it to be or thought it was, then perhaps you can get a patent on kind of a fine accommodation of details. So, okay, it's not the desk with the platform and the legs that extend down from the platform and the drawer. It's about the fact that it has wheels at the bottom of the desk and that the drawer has a lock. Not features that would typically be patentable, but let's just imagine that it's those further features that then differentiate it. Now you're getting patent on the fact that the desk has wheels and a lock. And now to infringe, someone else has to make a desk with wheels and a lock. And that might be too narrow. That might be too specific. The customers might not care about whether it has wheels and a lock, and therefore it's not really effectively preventing competitive listings. And but often you'll go to a patent attorney, they'll do a patent search, they'll tell you you can get a patent. But what they don't discuss is what the scope of that potential patent would be. And that's what you want to figure out, is you want to figure out, are the things that make your invention different enough to be patentable? Are they also things that are going to matter to your customers? And because if they don't matter to your customers, it might not be worth patenting. So you want to take a close look at the potential scope of the patent that you would get before you make the decision to go ahead and spend money on applying for a patent. Okay. And so now, assuming that you do want to go ahead and apply for a patent, then what's involved is creating a patent application. When it comes to a design patent, it's a bit simpler. It's all about making very precise drawings to meet the requirements of the patent office. That's the crux of a design patent application. So design patent application tends to be quite a bit less expensive than a utility patent application, because a utility patent application involves a lot of writing, a lot of description, making the point of what makes the invention different from things that have been done before and why it's worthy of a patent. So it's a much bigger decision of whether you should go ahead and put in an application for a utility patent, because, again, it costs more. A lot of times what people do, if they're headed towards a possible utility patent, is they do a provisional patent application as a temporary measure. You see, you could file a provisional patent application as a stepping stone towards a utility patent. And what the provisional patent application would do then is gets your foot in the door at the patent office, establishes your priority toward getting that utility patent, and it gives you a year to finish it up with the full utility patent application. But keep in mind that the priority you get is only as good as the application is well written. So the notion of like just putting together a quick description, filing it as a provisional application isn't going to really protect you. It has to be a well-written provisional patent application to fulfill what it really is intended to do. The other thing to keep in mind is that a provisional is not a stepping stone toward a design patent. You can't use a provisional application to put off filing the full design patent application. A design patent application has to a design patent application is the only path toward getting a design protected. Once you file either patent application, the design patent application or the utility patent application, then it's going to get in line at the patent office to be reviewed by an examiner. The examiner is going to review the application. They will consider whether it's whether you've dotted the I's and crossed the T's sufficiently to have it be approved. And if it's approved, then certain issuance fees will need to be paid, and then the patent will be granted. And once the patent's granted, then in the case of a utility patent, the term of the patent is 20 years from when you initially applied. So 20 years from the filing date is the term of the utility patent application, of the utility patent, I should say. Also keep in mind, though, that the patent could expire early if certain maintenance fees aren't paid. So maintenance fees are due at 3.5, 7.5, and 11.5 years after the patent is granted. Now, in the case of a design patent, the term is 15 years from when the patent is granted, not from when the application was filed, but when the patent is granted. So the design patent will last for 15 years, and there are no maintenance fees to be paid. So you will have that design patent for the full term of the patent without paying any additional fees. Okay, so that essentially covers the basics of what of how you go about getting a design patent or a utility patent. And in the next module, we're going to talk about trademarks and how you use trademarks to protect your branding. And I'll just extend the offer here that something that I've extended in previous Freedom Ticket modules that I've recorded with Kevin King, and that is that I wrote a book for the American Bar Association that explains how patents work. And if you want to learn more about patents, I'm happy to send you a copy. By the way, it's called the ABA Consumer Guide to Obtaining a Patent. That's what it looks like. You can get it on Amazon. If you contact my office, we'll send you a copy. Just email my assistant. The email is actually assist, ASSIST, at goldsteinpc.com. Just send your name, address, and phone number, and we'll order one through Amazon and we'll send it out to you. But that's it. Happy to hopefully increase your knowledge about patents here. And again, in the next module, we're going to talk about trademarks and how trademarks can be really effective for you in your journey selling on Amazon.